Society, and History Constellation at Ideas. I warmly welcome you all to this book talk on Professor Krishna Anand's Constitution of India, 75 Years of the World's Largest Democracy. My name is Sheikh Asad Arman, and I am a master's student at Jindal School of International Affairs. I will be moderating today's session. Before we begin, I would like to briefly introduce Office of Interdisciplinary Studies at OP Jindal Global University. Ideas is dedicated to advancing social sciences scholarship through innovative collaboration in research and pedagogy. Positioned at the intersection of diverse fields, Ideas brings together ideas, methods, and perspectives that cross traditional interdisciplinary boundaries, encouraging new ways of thinking and meaningful engagement with contemporary social issues. Let me briefly outline the format of today's session. We will begin with remarks from the author, followed by comments from our two discussants. I will then pose a few questions to the panel, after which we will open the floor for audience questions. We will conclude with closing reflections. In terms of time, 15 to 20 minutes for the author, 10 minutes each for the discussants. Then we will be followed by discussions and question answer session. With that, let me introduce our speakers. Our author of today, Professor V. Krishna Anand, currently teaches history at Sikkim University, Gangtok, an alumnus of Jawaharlal Nehru University. He has worked with the Hindu, reporting on national politics and contributing to editorials and op-eds. He has also practiced law at the Madras High Court and as a fellow at the Nehru Memorial Museum and Library. His scholarship traverses history, politics, and law. His previous works include India since Independence, Politics in the Times of Churning, and also the Indian Constitution and Social Revolution. His latest book continues this engagement with constitutional questions. Our first discussant, Mr. Venkateshan, is Senior Associate Editor at Supreme Court Observer and has spent nearly 3 decades writing on politics and law with Frontline. His book, Constitutional Conundrums, reflects this deep engagement with democratic processes. Our second discussant, Mr. Manvender Singh, is a faculty member in history at SRM University, Andhra Pradesh. His research focuses on caste, modernity, and constitutional thought, particularly the judicial and epistemological dimensions of caste in India. His work has appeared in economic and political weekly and major academic publications. With that, let us begin. I invite Professor V. Krishna Anand to deliver his remarks. Thank you. Over to you, Professor.
You're muted, Professor.
Yeah. Okay. Now, am I audible now? Yeah. Okay. Let me I think I have about 15 to 20 minutes. Am I right? Yeah.
Right.
Okay. Let me very briefly get into what actually got me to do this book. In a sense, I mean, for some time, there was this, quite some time ago, there was this talk about the Constitution has to be completely rewritten. In a sense, like, it has gone through several amendments and, what we need is another constitution because, whatever was adopted by us has to be, undone and, done again. There was actually a commission that was appointed consisting of jurists and all those people. And, quite rightfully, they said that, like, it's not a question of rewriting, but there are a few things that probably can be brought into the constitution. So ever since then, I was actually beginning to sort of think in terms of, what it is. And 75 years of the Republic, in fact, was just a kind of a moment. I thought, this is when one has to do that. Having said that, once I embarked upon it, and that is what exactly the book is about. It's in 3 sections. Chapters 1 to 5 essentially argues it is essentially a kind of an attempt to establish that some of the myths surrounding, the making of the Constitution. I mean, there is one such myth that, a group of brilliant men who are scholars in law and constitutional law, they got together some of the best parts of the American and the English Constitution and put them together. And while doing so, they also blended it with some aspects of the Constitution of Switzerland and so on and so forth. The second myth, of course, is something that is gaining popularity. Particularly, it's a populist kind of a myth, in the sense that, this is a constitution given to us by Ambedkar. And the third myth about it is look, there was nothing great about the Constitution. It was basically the Government of India Act of 1935 that is what the Constitution is. In some ways, none of these are absolutely untrue. Myths are always built on some kind of truths. You cannot actually build a myth out of nothing. But however, over a period, it turns out that any one of these myths, and as myths are generally created, myths are always created, and it serves a certain kind of a purpose of the present. So the first 5 chapters, chapters 1 to 5, in the book actually is an attempt to establish that the Constitution was not written overnight by 7 bright men sitting together, nor was it an attempt to put together everything that was good about the American and the English Constitution, nor is it that it's just the Government of India Act. Now let me come to the Government of India Act. It is there very much in the Constitution, particularly after Part 5 of the Constitution. A lot of it comes in what we call the administrative law, and these were all broadly taken out from the Government of India Act. And the reason why actually these were done into the Constitution was explained very clearly by Dr. Ambedkar when he said that, when we have all these things, and it is as well good, and it serves a purpose if we put all of them together. Now about the second myth about yes, I think Benegal Narasimha Rao actually took various aspects of the constitutions from across the world, not just the US and the UK, but from across the world. And he, in his notes that he submitted to the drafting committee through the Constituent Assembly, had actually in the left-hand margin had substantial marginal notes on what this is. And Ambedkar himself explains there is a charge, or there is a talk that we have taken it from various other constitutions across the world. And he says that we have had the advantage of working on a constitution at least 200 years after the first ever constitution came into place. And what is wrong if we have actually taken the best parts of it? But the third myth, and that is where I think the first 5 chapters come into, the foundational doctrines of the Constitution of India. And if I can say that, the fundamental rights, Part 3 of the Constitution, and Part 4, that is the Directive Principles, are the most substantive aspects of the Constitution. There, I think, as a historian, I was able to trace that almost every sentence, almost every word, or every clause, or every article that is there in the fundamental rights and the directive principles had their origins from the Motilal Nehru Committee report as submitted in 1928 in response to the Simon Commission's visit that the colonial rulers wanted to tell us that we are going to teach you how to rule yourself. And the International Congress appointed Motilal Nehru as chairman of a committee. And if we look at the Nehru Committee report, we find for once there is this a full kind of a chapter there on fundamental rights. And if we read the fundamental rights there, then coming into the Karachi Session Resolution, which is again called the Fundamental Rights Resolution, and finally coming to what happened. And quite interesting, there was a Fundamental Rights Subcommittee of the Constituent Assembly. And they had actually completed the works on drafting the fundamental rights as early as sometimes in early 1947, in February 1947. This is much before the Universal Declaration of Human Rights comes into place. So in a sense, it was the struggle for independence that probably inspired the the foundations of the Indian Constitution. And in that sense, I mean, I will partly agree with Aditya Nigam in this book that this is the Constitution is it's a text without an author. However, I would go one step further to say that the people of India and those who contributed in their own ways to the struggle for independence were, in fact, the authors of this Constitution. So this is what I try to establish in the first 5 chapters. Then chapters 6 to 9, that is 4 more chapters, deal with what happened to the Constitution after it was adopted. So chapter 6, for instance, is talking about the First Amendment, where there were 3 important principles that actually sort of, I mean, it turned out that the Constitution drafted did not really sort of, address to the concerns of the makers of the Constitution insofar as justice, social, economic, and political. So the First Amendment had these 3 legs. One is social justice. There was this Champakan Thorarajan case from Madras, which was finally adjudicated in the Supreme Court of India, where it said that, there was no provision in the Constitution. Rather, the Constitution did not allow reservation for scheduled caste students in professional colleges, in higher education institutions. And that's where the founding fathers of the Constitution, they themselves reassembled. In fact, it wasn't a parliament. Parliament was still not in place. In 1951, the Constituent Assembly gets back to make an amendment to the Constitution, that is by inserting Article 15(4) and ensures that reservation for the scheduled caste in educational institution was constitutional. That is social justice. Economic justice, just after the Constitution came into place, and within no time, there were land reforms legislations in Bihar that were actually declared or called unconstitutional by the Patna High Court, the Zamindari Abolition Act. And the challenger, that the petitioner in that case happened to be a member of the Constitutional Assembly, that is Raja Kameshwar Singh of Darbhanga. He had opposed Zamindari abolition inside the Constituent Assembly. And after the Constitution came into place, he goes to the High Court, and the High Court says, yes, this is not proper because Article 31, though, has been taken care, Article 14 has not been taken care, and that leads to the First Amendment bringing in Article 31A, B, and so on and so forth to sort of, make sure that the intent was taken care. Then there was the third leg of it, like, to insert public order as a ground for curtailing the freedom of expression, which perhaps was more out of some kind of a knee-jerk reaction to an observation in the Patna High Court that things can go awry. Then we have the second important stage in this whole trajectory, where the Constitution, gets amended several times, and that is with regard to the right to property. The Fourth Amendment, the 17th Amendment, and so on and so forth, which leads to some of the very important gaps, perhaps in the Constitution, being identified by the judiciary and the legislature, that is Parliament, actually trying to sort of fill in those gaps and make sure that the land reforms legislations are taken through. But this spurred another important kind of a debate as to whether the judiciary is supreme or Parliament is supreme in a democracy. In a sense, this also took some of the judges of the Supreme Court actually saying that, you cannot do this, leading to the Golaknath. So I deal this with in chapter 7. And chapter 8 is the 42nd Amendment that took place during the emergency. Perhaps the darkest chapter hitherto in the history of the Constitution, which I deal with in detail as to how the amendment got in, what were the problems with it, those who opposed it, the limited number of people who were inside Parliament, where the debate is discussed in detail. And then the 44th Amendment, which perhaps undid almost everything that went wrong with the 42nd Amendment. I would call it, the chapter is titled The Constitution Restored. the constitution restored. And in this particular chapter, I do point out that in 1977, there was an opportunity, that is in 1977-79, when the Janata came to power, there was an opportunity for those who actually sort of, were in the cabinet. I mean, except about three, almost every member of the cabinet, that is, I'm talking about the Moraji Desai cabinet, happened to be prisoners under preventive detention law, that is the MISA. There was an occasion for them to reopen as to whether preventive detention laws should at all be there in a constitution in a democratic republic. They did address to that, but not the whole scale. In fact, it was possible for them. It should have been, the most ideal thing would have been to delete Article 22 of the Constitution, which gives sanctimony, kind of the legitimacy, constitutional sanction to any kind of preventive detention laws. But the Janata government or the cabinet actually did not walk the talk, the whole hog, and which I point out in the chapter that I deal 44th Amendment with. Chapters 10 to 14 are chapters that discuss some of the very important judgments of the higher judiciary, that is particularly the Supreme Court, on a thematic basis. For instance, chapter 14 talks about the swings that the higher judiciary took between one extreme and another extreme on agrarian reforms. That is the Shankari Prasad Dev case to start with, ultimately ending with Keshavananda Bharati and reconfirmed with Minerva Mills, where the judiciary was sort of, straddling between the rights of the property class and the rights of those who were going to be emancipated in a very limited sense of the term. And Golaknath becoming the high point, the bank nationalization case becoming the high point, where the judiciary outrightly stood by the property classes, and how the Keshavananda Bharati judgment in 1973 restored the whole thing. That, and particularly I deal with Justice H.R. Khanna's treatment, or rather comment in his own separate judgment, where he says there is something called the basic structure of the Constitution, and doesn't stop there. Unlike the six others who talked about the basic structure in that bench, he goes on to say, I can say that the right to property is nevertheless not part of the basic structure, which actually clinched the whole thing, and the deletion of Article 31 from Part 3 and inserting it as a mere constitutional right, that is 301A. Yeah, so this is what chapter 11 deals with. Chapter 10 deals with. Then chapter 11 is again about this whole preventive detention laws. Once again, how the judiciary swung from a point, that is A.K. Gopalan, perhaps the most discussed case law in India's judicial history, constitutional law history, and how actually from there, in the case of Maneka, or maybe R.C. Cooper, that is the bank nationalization case, the judiciary actually sort of, shifts from what it was in A.K. Gopalan, that is procedure established by law, to R.C. Cooper, where actually it shifts and adopts what is called in jurisprudence the due process of law. And in the course of this chapter, I once again go back to the debate inside the Constituent Assembly. Incidentally, it was the due process of law under Article 31 all the while. And it was in the last stages that the drafting committee rephrased it as procedure established by law. I'm so sure, those who follow law as a discipline will actually need not, but it can further be explained if necessary. This particular shift also demonstrates how the judiciary, particularly the higher judiciary, had at various points of time agreed to swing its own kind of principles when it came to the rights of the property class. Because R.C. Cooper was about the big bank owners. And in that case, the Supreme Court says that the impact of Article 31 or a decision under Article 31 vis-a-vis on Article 14, on Article 19G and all, will also be factored in while deciding. And they outrightly say that A.K. Gopalan was decided wrong. I mean, it was perfectly fine for a larger bench to do that, but the point is the context was that, they did this in terms of, in terms of sort of, standing by the property classes, which is again sort of, it was again manifest when Maneka Gandhi case happens in 1978. The judiciary stands up for her political rights. Nevertheless, a whole lot of preventive detention laws, particularly from the 1980s and to the present, actually sort of, continue to have its own kind of what we call the stamp of approval when it comes to political prisoners, otherwise than the property class. Then there is this long theme from Champakam Rajan vis-a-vis reservation until Indra Sani, that is what is otherwise called the Mandal Commission case, where the judiciary, after swinging here, there, and everywhere, finally, actually, in the Indra Sani case, there is a majority judgment that upholds certain principles that class and caste are not two distinct categories. There is an overlap. And a class that is backward can also be a caste that is backward. And a very important question being settled. I also touch upon a subsequent judgment where I call it judicial indiscipline in that process. Then there is the other important element of, let's say, the Indian Constitution, and that is what we can call the federal principles. Of course, the Constitution doesn't use the federal anywhere except in that particular article where there is something called the federal court. In other words, the Supreme Court. But federalism was very much, pretty much outlined in the 7th schedule, that is the powers of the states, the powers of the center, and the concurrent list. And what came out particularly was a kind of a political abuse of Article 356, that is playing around and beating state governments by the union government. And this is where the judgment between the state of Rajasthan, where the Supreme Court held that we will not go into probing the factors behind the governor or the president's mind before taking a decision. From there to the Bombay judgment, where they say that the actions are justiciable. In other words, whatever went into the mind of the governor shall be probed by the court by way of documentary evidence. And finally, I think, there cannot be a book on the Indian Constitution without discussing the darkest hour of the Indian judiciary, and that is the ADM Jabalpur moment that, those in constitutional law would call, when the Supreme Court, 4 out of 5 judges of the Supreme Court, 2 of them incidentally became Chief Justices after that, denied the right to the writ of habeas corpus to those who were prisoners during the emergency under MISA. Something that even, at least 11 high court judges, 11 judges of various high courts had shown the spine to allow such petitions based on case law and so on and so forth, whereas the Supreme Court judges, 4 out of them, in fact, just shut the door on any kind of democratic rights for political prisoners at that time. Of course, the law was changed thanks to the Janata Party coming to power, and as part of the 44th Amendment, that the right to writ to habeas corpus can no longer be denied by a certain. So when saying all these things, I must also say that, this has been an account of what happened with the Constitution over a period. And, as it becomes the problem with writing books, I was not able to sort of, look at everything that involves the Constitution, number one. Number two, my concerns stopped with, let's say, 5 years before the 75th year, except in parts. It's possible today that, there is the right to writ of habeas corpus that is absolutely sort of, undeniable. Nevertheless, we all saw that, this whole writ petition, the fact that, it remained, without being decided by the Supreme Court for as long as 6 months in the case of Sonam Wangchuk recently. So in a sense, the book also sort of, throws this whole thing that what we have is a wonderful constitution. We have a constitution which can be mended where it goes wrong. But then what is significant is you need the political will to work the constitution. And where there is no political will, the constitution that is pretty much wonderful can also go wrong. Having said that, I think, in the book, I do make a point that, Article 22, I mean, the long history of it, it should not have been there. It was not there in the draft that Ambedkar presented, but Ambedkar comes out with an amendment subsequently with Article 15A, which becomes Article 22. And that perhaps, I think, I mean, I use the biblical concept of original sin. I thought that, a political democracy suffered from that original sin that was committed with the insertion of Article 22 into our constitution, and it remains one of the weakest points of a democratic constitution. So I hope I try to summarize what is there in the book, and now I leave it to the fellow discussants to take it over. Thank you very much.
Thank you, Professor Anand, for those insightful reflections. I now invite our first discussant, Mr. Venkateshan. Sir, over to you.
Thank you, Krishna Anand, for the illuminating introduction to your book. Especially the chapterization, how you went about it, the themes which focused on the chapters, etc., etc. And also, thank you also for linking the book to the contemporary issues. How preventive detention continues to be debated by in the public discourse because of the arrest of someone or the other under this dreadful law. Now, having read the book, my overall questions and the concerns which I keep getting is that you did very well in linking the politics of the moment, and also with the amendments, the laws, etc., because these two are intimately tied. As you evolve the history of trace the evolution of the Constitution right from the inception, the politics of the day cannot be diverged. So this is the whole theme of your book, which is well taken, because very often we find that constitutional law scholars, do not go into the politics, but you maintain this argument that politics influenced the constitution making, the evolution of the constitution, and the way in which constitution shaped itself, over a period of time. So the political events leading to the constitutional changes, the amendments, that is one thing, and the constitutional changes themselves leading to political changes. These are all overlapping things. Now, the question is the foundational compromise, which you had mentioned in your book. Very often, as journalists, we always, deal with the authoritarian tendencies in the contemporary state. So the answer to this, as you would point out, this is there in the foundation. There was a foundational compromise. Our founding fathers had made this compromise. They had retained the authoritarian aspects because of the peculiar historical circumstance prevailing at that point of time. So these compromises were inevitable, so they remained till this day. So that is one thing. So my question based on this is that, so because of this foundational compromise, the authoritative tools which we come across these days, the curbs on the freedom of speech and curbs on political protests. So all this, emanating from those authoritarian tendencies, do we have no option but to resign to the fact that, these are foundational compromises, we can't do anything about it? But constitution is also looked at as a transformative constitution. So that is what we call the originalistic school and the transformative school. So originalism means, you have to go to the constituent debates and what the constitution, the fathers and mothers had thought about it. So whatever they had said, that continues to guide the interpretation of laws, as Supreme Court often does. Another way of looking at it is, oh, it's transformative. Constitution makers might have said something, based on the prevailing circumstances of that day. Those circumstances, those debates need not guide us now because circumstances have changed. So there is nothing wrong in changing the constitution, because the basic thrust, whether in 1950 or now, the basic thrust is transformative. So therefore, if the transformative ethos of the constitution demands certain things, we should go for it. We should not mind changing the letter and spirit of the constitution for the sake of transformation. So this is one of them. My another normative kind of interpretation of the events, of the political events of the last 7 decades and the constitution. There is a view that each election produces a kind of government, right? The government may be a super majority government may be a coalition government, or a weak government, whatever it is. But invariably, the belief is that a government which enjoys super majority in parliament, right? As long as it has super majority, the judiciary is always subservient, to a popular government at the center. So that is one impression. I don't know whether it is correct or not. To some extent, it is not correct. But this belief has gained ground, especially in the 90s and after that. Because if you look at the politics of the 90s, very often find coalition governments. But the judiciary became very powerful during that period, 90s. And in the post-80s also, the judiciary, because of the emergency, wanted to regain its lost prestige. So it started, its pro-people period. So in after 2000s, you have this coalition government continuing. So the Supreme Court always, giving activist rulings during that period against the government. Many of the instances we can see. But after 2014, when we have a super majority government at the center, the Supreme Court seems to be differential to the government. So many people have said, oh, this is because of the nature of the government influencing the way the court functions. But is it a correct way of looking at it? Because in the 50s, you find that many rulings of the court going against the government, though it was a majoritarian government. So but this trend continues even up to 70s and late 70s. So slowly we find that judiciary becoming more and more assertive in the 80s and 90s. Again, is now going back to the differential period. So do you see any correlation between these two phenomena? That is one thing which I don't know whether you had touched this subject in the book, but if you can clarify on the basis of your scholarship, that will be very useful to observers like me. And the second point which I wanted to make, so if I'm crossing my time limit, please alert me. The second point which I wanted to make is, if you see the, especially in the recent period, Narendra Modi's third term in power, right? We find many laws which are keeping the judicial review out. But if you look at the post-emergency period, the judiciary has always been very mindful of its turf. So if any particular law keeps out judicial review, it will strike down that law. It happened in Raj Narayan case, right? So, but right now we find that there is hardly any debate on this. You have the Chief Election Commissioner's appointment law, which keeps out judicial review. You have a transgender bill, again keeps out judicial review. So there are other instances. I was surprised because yesterday I was reading the latest Central Paramilitary Forces Bill. That also keeps out judicial review. So there are so many laws which are now being enacted in Parliament which specifically says judicial review is out. So how will the court look at this, especially when the majority government there? So will it become differential, or will it say that our tough is tough, we cannot have any compromises, these bills are unconstitutional? So that is one. And recently our Prime Minister completed more than 8,900 days in office, starting from his days as Chief Minister of Gujarat. Now, why is it that we don't have a term limits for Prime Minister? Is there a constitutional reason? There is a term limit for President. Okay, not specifically mentioned, but out of convention it has evolved. The President doesn't contest, doesn't have more than 2 terms in office. But we don't have any term limits for Prime Minister, which is more powerful, which is the central place of the executive. But if you look at other constitutions, the term limits are always there, whether it is for President. And in the case of UK, what we find is that the political parties themselves have a check on the term. So if you look at Margaret Thatcher, for example, the Conservative Party exercises the check and then removes her from power. Okay, though the UK doesn't have a written constitution, even in terms of convention, there is no term limit, but the term limit operates through the political party. Now, what happens in India? Till 1985, there was no problem because the Constituent Assembly, I understand, discussed this issue of term limits on the Prime Minister and ruled it out. Rightly, probably because they thought that a popular leader like Prime Minister cannot be subjected to a term limit. But they also thought, because Parliament is there and the Prime Minister of the day will always be subjected to daily checks, greater accountability, which is not possible anywhere else. So this accountability part would be very well taken care of. So we don't require a term limit as such. That was the answer of the constitution makers. But in 1985, we have this Anti-Defection Act, 10th schedule, enacted during Rajiv Gandhi's time. So what happened? This effectively neutralized the role of political parties in unseating a leader. So any member of the political party going against the whip of the party is likely to face disqualification. So because of that, the Parliament exercising effective control over the Prime Minister is not happening, right? So my question is, have we gone away from the vision of the constituent makers as far as the accountability aspect is concerned? Because the absence of a term limit on the Prime Minister, on the executive government, and the corresponding checks and balances to the constitution makers had thought of initially, those checks and balances are no longer in existence because of the Anti-Defection 10th schedule coming into force and playing havoc since 1985. So how do we look at this issue? That is another one. Now, there have been quite a, as a journalist, I look at the contemporary issues. I look at the constitution in terms of the contemporary issues, how we debate those issues. So we have the latest judgment from the Supreme Court on the Dalits losing their Dalit status after conversion, if it is not Buddhism or Sikhism. So they convert to another religion, they are no longer Dalits. So the protective shield disappears the moment they embrace another religion. So this kind of judgment, when the the opposite view has still not been resolved academically. Whether Dalits continue to suffer discrimination, ostracization, and various forms of oppression even after conversion. Whether they are eligible to be protected by the Constitution's protective umbrella. So that has not been resolved. But the court has resolved it, saying no, they are not eligible. So what happens to this? Protective discrimination. Is it limited to and will it be at some point also extended to the reservation to some extent has been denied to the converts, saying that if you convert just for the sake of reservation, then it's not recognized, right? So there is a tension here which needs to be resolved. So how, as student of the Constitution and the Constitution scholar, you look at this debate? That is another one. So you have, through the book, we have talked of the uneven record on civil liberties. The court is coming to the aid of civil liberties at some point and keeping a distance from it. So we come across the same kind of tension in the contemporary times also. So in some cases we find Supreme Court coming to the aid of citizens, saying that freedom of expression is foremost and it should be protected at all costs and all that. So this kind of lip service is absent when it comes to other issues like NCERT textbook controversy. When the court said, no, we can't you mention about corruption in judiciary, so you have to ban that book. So this kind of tension is always there. The court is not able to resolve the dilemmas which it has created itself. So there are other issues. I don't think you might have dealt with the contemporary issues in this book, but given your scholarship, how do you look at one nation, one election, for example? Is that a constitutional basis for that? And increasing the parliament's strength from 534 to 800 something, which is going to take place from 2029. So we are going to have women representative in as many as 233 seats or something. So how do you look at this huge phenomenal change which is waiting to happen within a few years from now? How will it influence the course of Indian Constitution as well as history? These are my broad questions which Professor KRISHNA should explore and answer, so that as contemporary students we will be in a position to better understand the future of our Constitution and future of Indian polity. Thank you.
Thank you, sir, for the engaging intervention. I now invite Dr. Manvinder Singh for his remarks. Over to you, sir.
So I think I get 10 minutes, right? Close to 10 minutes, right?
Yeah.
So let me first of all thank Dr. Ambi Naga for inviting me to speak on the book and sharing the pleasure to engage in a conversation with Professor KRISHNA and Dr. Venkatesan. Since I have been given the task to speak on a book, or rather give a remark on a book which extends to more than 1,000 pages, and given the time, I would like to read something, and something specifically how one should read the book as well as the Constitution, something which Professor KRISHNA Anand itself insists in his book. So let me start. And particularly at a moment when the Constitution is invoked frequently in public discourse, particularly in the last, let's say, 10 years or so, often as a symbol or as an idea of justice, or as sometimes as a site of contestation. In that sense, I see this book, which asks us to return to look at Constitution not merely as a legal document or a text, but also as a historical and political project. This is where I would like to locate this book. The one one way in which, at least I have read this book, and I would also suggest others to read this book as well as Constitution, is to suggest that when taken seriously and read book in a certain way I have done, I would invite that we might look at from a contrapuntal reading of the Constitution, something which I am picking from what Edward Said speaks of how one should look at the post-colonial state, and a text also. So, in a sense, if we do a kind of a contrapuntal reading of the book as well as the Constitution, we then attend to multiple voices within a text, not only one that dominates or are the authoritative voices, which we often tends to in the Constitution as well as in the judicial cases, which Professor Anand has already mentioned, and I will also speak about it, one particular in that sense, ADM Jabalpur case. But contrapuntal reading then, also invite that we look at marginal, dissenting, or voices that have been suppressed, right? In a sense, which the book also does, we are reading Constitution that refuses to collapse complexity into a single narrative. Much like on the case of reservation, as Professor Anand has mentioned, that one look at the constant assembly debate and then subsequently the First Amendment, and then let's say what Professor Anand has mentioned about the case of judicial indiscipline, which A. Balagopal in his article in 2009 mentioned about a judgment by Ashoka Thakur, in which what court was not asked, court was essentially asked whether reservation in private institution is legal or not. Instead of commenting on that, court went back and dealt with the question of whether creamy layer is justified or not. So these kind of questions, how do we locate then Constitution? How do we read Constitution? So I want to argue that this book's perhaps not explicitly, but certainly it's in method and material, allow us to read the Constitution in precisely this way, like I said, contrapuntal way, as a layered archive of competing arguments rather than a unified singular text. In this sense, this reading builds on Professor Krishna's own insistence that constitutional meaning emerged to conflict, reinterpretation, and historical context. I think, in his book also these three contexts, or at least, insistence comes out very clearly, that is conflict, reinterpretation, and historical context. To sort of make my point more clearly, and sort of get into something which I would like to talk about is to look at the question of dissent. So, within the Constitution, and when I say Constitution, judiciary as well as the assembly, right? In fact, building on the book's emphasis on the context, we might also read the debates, and when I'm saying debates, the constitutional debates, shaped by the political milieu of decolonization, particularly the intertwined history of colonial rule, nationalist history, anti-caste struggles, and partition, alongside, and this is where I would like to put an emphasis, a desire for modernity. Not only the constant assembly debate, but later how one interacts and sort of understand Constitution, which together generated specific kind of anxieties around the question of unity, social justice, social transformation as well, and the question of diversity. These were not merely background conditions, which I think Professor Anand mentions very clearly in the first part of his book. They actively shape the terms of constitutional debate in the first half. And let me sort of repeat what Professor Anand sort of said, that one can look at the question of due process versus procedure sort of established. When you look at the First Amendment, the court, when petition was put by two Brahmin students who in fact had not applied in a medical college in Madras, saying that if they had applied in the college, their admission would have been denied because of the communal geo that was in place in Madras. Now the court read the Constitution in verbatim, and when I'm saying read the Constitution, only a particular section of the Constitution, Article 14, which said that equality before the law, failing to read the intent of the Constitution that lies in the preamble. And this is where, instead of reading Constitution as the procedure established, due process becomes essential. Something I would like to talk about more when we come to ADM Jabalpur case, something which Professor Anand has mentioned extensively in his book. It highlights that how even the drafting committee, which Professor Anand also mentioned, their initial inclination was towards a stronger protection of liberty. Right? In fact, it is in this case that Ambedkar would side with someone Nehru, saying that the state should have a much more centralized law, so that the questions like reservation on social justice can be implemented everywhere across India with uniformity. That is one. Now, this inclination also comes, or this debate whether stronger protection of liberty was modified through political intervention at the last moment, something Professor Anand mentions in his book. Now, what I would like to suggest is that rather than reading this simply as a compromise, we can also see it as an evidence of competing constitutional possibilities. These possibilities would emerge very clearly out in First Amendment. These possibilities would emerge later in Keshwanandan Bharti case. These possibilities would emerge in post-Mandal case, in which whether the reports submitted by the Mandal and recommendation which were suggested by Mandal were constitutional or not. So in fact, we should read any dissent, and whether it is coming from the Constituent Assembly debate or in a very important case that was settled by the judiciary, that how these competing constitutional possibilities being articulated and debated, how some of which did not prevail or were sidelined in the process. Now, let me come back to the question, to the case, which sort of can, I can make my argument, the ADM Jabalpur case. As Professor Anand mentioned, this case itself becomes, in his writing itself, it comes out a very, a central piece of his argument. And one of the reasons is because when the question of emergency is touched upon, the discussion on ADM Jabalpur case, this often reminds us as one of the darkest moments in Indian constitutional history, in which the Supreme Court by majority held that emergency, even when the right to life and liberty could be effectively suspended and taken away in the process, the court should not and could not entertain such petition challenging unlawful detention. Again, the court read the provisions of the Constitution as it was written, instead of going beyond and looking at the question of natural justice, which is essence of what we call as the due process, that whether such laws infringe upon certain natural rights which are guaranteed in the preamble, and in fact are part of the anti-colonial and the nationalist struggle. The standard interpretation of this episode is that it represents a failure of judiciary, a moment when court abandoned its role as a guardian of fundamental right. This is the standard reading. Now let me just talk about how Professor Anand sort of reads in his book. He complicates this narrative and suggests that the judgment was not entirely outside the constitutional framework, right? But in some ways, the Constitution and as well as judiciary, through its long course of engaging with such question, enabled suspension of such laws. In other words, Constitution itself contained the possibility of such an outcome. And a point that is deeply unsettling, but in fact, I felt is very important insight which Professor Anand makes us in a book. Now, let me just also interject here and speak about that how one can read ADM Jabalpur case contrapunctually and understand that the question of dissent. If we read ADM Jabalpur only through majority judgment, we encounter a constitution that appears to sanction suspension of liberty in the name of state power. But if we read the case alongside Justice H.R. Khanna's dissent, which becomes very important, we encounter two different constitutional visions, where Justice Khanna would say, even without Article 21 being suspended or never being there, state has no right to take life and liberty, sort of emphasizing the due process. The majority reflects one interpretation of constitutional authority under exceptional circumstances. If we are going to read Constitution as it is written and as given to us, while dissent articulates a stronger commitment to liberty, the question of liberty, a contrapuntal reading does not resolve this tension. And this is much more important, I think, perhaps the point which Dr. Venkatesan has also made, that in that sense, one need to also understand that the contrapuntal reading does not resolve this tension, but in fact holds both together, that these both possibilities remains together, where the possibility of suspending liberty and also protecting liberty even when Article 21 is suspended remains, in a sense recognizing them as part of the same constitutional history, right? And let me sort of conclude with this point, where dissent, and this would be a question also which I would like to pose to Professor Anand, that where dissent is just how one should read the question of dissent in long judicial and constitutional history. This dissent as merely a disagreement, as read in the Constituent Assembly debate or Legislative Assembly debate, or even in fact in judicial cases, or is it a constitutional resource then? As we have seen, when A.K. Gopalan was arrested in 1950 by the Nehru government, a member of Communist Party, and the court, and when he went to the court very clearly said that his detention was held legal, given, and the argument that the court gave is that it is under the law that remains justified. Something that was overturned in the Menka Gandhi case, when her passport was suspended, and the court said that right to life and liberty cannot be taken away with an arbitrary without any due reason given by the state. So it cannot be arbitrary, right? In that sense, dissent then becomes a constitutional resource. It keeps open alternative future within the text. In this sense, dissent performs at least three important functions, which I could see, Krishna Anand's book sort of in various forms and ways talking about it. It preserves the interpretation that may not immediately dominant, but remain available for future interpretation. So the dissent might not reflect to the dominant discourse of the time. Like for instance, in 1960s, reservation was seen as anti-merit and anti-efficiency, something, and there was always a judge who would have argued against it, something that was revisited in 1990, and that became the dominant position, that reservation in fact is not anti-merit in the post-Mandal episode. So in that sense, it preserves the interpretation that may not immediately dominant, but remain available for future interpretation. Second, it exposes the limit and contradictions within the prevailing constitutional doctrines. Third, it serves, and much more importantly, it serves as a moral check on institutional authority, reminding us that legality and justice are always not same. So these two questions, most of the time, have remained sort of intertwined and sometimes dealt separately. And if you give me 2 minutes, I would like to conclude then with a kind of a question also, and a sort of my own understanding of the book written by Professor Anand. This way of reading also has implication for how we think Constitution today. If dissent has been historically central to the development of constitutional meaning, what does it mean for contemporary public discourse, where dissent is often viewed with suspicion, and not only in contemporary discourse, but if one has to look from 1950 with the Nehruvian state also, that has been consistent, where dissent is often viewed with suspicion. What happens to a constitutional culture when dissenting voices are marginalized, not only in courts, but in public sphere more broadly? And this is where I would like to end with a question to Professor Anand. Given that Professor Anand emphasizes on locating the political context in which we are reading Constitution, does the anxieties of the post-colonial state on the question of unity, order, and social transformation, or the question of social justice, continue to shape how constitutional provisions are interpreted today, or even in the aftermath of independence? I rest my argument. Thank you so much.
Thank you, Dr. Singh, for those important insights. Professor Anant, you want to give response to Dr. Singh now? He posed a question. Like, yeah, you can go ahead.
Yeah, in fact, what I'll do is I'll try to keep it as short so that, there are more questions, if possible, from the others who are here in this room. Yeah, I mean, let me start from the last point of the question that Dr. Manvinder Singh actually posed. And that is, uh, I mean, if I'm, Dr. Singh, can you just repeat the last part of your question?
Unmute myself. So I was just asking, given that your emphasis on political context, does the anxiety of post-colonial state, I mean, from 1950s itself, on the question of unity, order, and social transformation, continue to shape how the constitutional provisions are interpreted today, and in fact, in the aftermath of independence or freedom?
Yeah. I think a very short answer to this, and a whole lot of questions that Dr. Venkatesan had posed also, is what Dr. Ambedkar said finally at the time of, I mean, on the 26th of November, when the Constitution was finally adopted in 1949, that what we have is perhaps a fine Constitution. That, and if it doesn't work, let us not blame the Constitution as such, but let us actually blame the men who work the Constitution, because men are wild. I think, I mean, and he was also talking about constitutional morality. In some sense, I would actually sort of, take this and, I mean, I will try to sort of, answer points raised by Dr. Singh as well as Dr. Venkatesan, and sometimes, I club them together. Now, for instance, about social justice and reservation. Dr. Venkatesan talked about, the recent Supreme Court judgment. In fact, between this and Ashoka Thakur, there was another instance of judicial indiscipline. There was another instance of judicial indiscipline when it comes to, let's say, the idea of reservation. And that was a 5-judge bench in a 3:2 judgment upheld Indrasani judgment, and particularly the majority, and the whole thrust of all the judgments with regard to, let's say, social justice. What comes out as a very central point is that reservation is not an economic amelioration program. It is meant to sort of achieve a social transformation. And all this was actually sort of watered down. And despite Uday Lalit and one of his brother judges actually giving a dissent against what was declared, let's say, in the Mandal Commission judgment by 9 judges or 11. I mean, correct me if I'm wrong. Now, that was what I would call sort of judicial indiscipline. The 5 judges had no business to sort of address this. But then, what is it that went wrong? And I mean, apart from actually sort of calling the judges as having committed this whole of being guilty of judicial indiscipline, I think what is more important is the Constitution and its making and its preservation is not merely the job of, let's say, the judiciary or Parliament. In fact, the entire debate through the 1960s until Keshavananda was whether the judiciary is supreme or whether Parliament is supreme. But I think, there is something else that went missing, and that is articulating this idea of the Constitution or the idea of India. And I think the platform that actually is equipped and it is meant to articulate that is the media. So when it comes to social justice, and I mean, I haven't come across a single journalist pointing out that the EWS also did not find anyone from across the political spectrum, except, of course, like, people who belong to what we can call the Dalit platform, calling the EWS judgment as an act of judicial indiscipline. And this is where I think the tenacity of caste I mean, Justice Ratnavel Pandian actually goes long into it. Justice B.P. Jeevan Reddy, I mean, gets so detailed into it. And on a previous occasion, Justice Chinnappa Reddy actually says what caste is and what it is meant. I think, I mean, even after the 75 years, this is one area where perhaps, I mean, look at it. The University Grants Commission comes out with a circular, which is more or less what the prevention of atrocities in scheduled castes and scheduled tribes actually lays down in criminal jurisprudence. The UGC circular is now sort of, I mean, the butt of all kinds of, agitation and so on and so forth, including from a particular vice chancellor who gets away scot-free with this. So I think, I mean, this is where what Ambedkar said becomes relevant. Now, I mean, having said that, what about dissent? I think, that was one another concern that both of the panelists actually raised today. I mean, is dissent a constitutional guarantee or is it a constitutional resort? I think the constitution as it was made contained both these things. In fact, Ambedkar talks about, let's say, the writ jurisdiction, Article 32, as the soul of the constitution. That is a constitutional guarantee. But then if we look at when we look at the language of, let's say, Article 19, 20, and 21 particularly, it's called the right to freedom. And when we actually sort of look at the language, it very clearly says it's a constitutional guarantee. The life and personal liberty of anyone shall not be taken without the procedure established by law. So in a sense, the Constitution it guarantees as much as provides the scope for a resort, particularly by way of 32 and 226, where actually the constitutional rights are denied, particularly the fundamental rights. Now, I mean, presuming that, I have tried to sort of, address to the concerns raised by Dr. Manmohan Singh, let me go to the specifics of what Dr. Venkatesan raised. Yeah, I mean, I don't think, I will anytime argue that, look, this is there and this is there in the Constitution and, we need to live with that. On the contrary, the Constitution, as much as it was a product of its own times, where I have problems. I mean, some of the provisions of the Constitution, for instance, when it comes to the context in which Article 15A that becomes Article 22 is introduced, in the book, I very clearly say that it was an original sin, that, it should not have happened. And I mean, I in fact, quote one of the members of the Constituent Assembly, even sort of, telling Dr. Ambedkar, you did not have the opportunity to go to jail, the colonial jail. And that is why you are bringing in this kind of a provision, which was very much part of the Colonial Administrations Act. Ambedkar, responding to it, says, I will look forward to an opportunity. This is all there in the Constituent Assembly, if you say so. And this member actually tells him, the Constitution or this provision that you have actually now introduced, it will certainly ensure that you go to jail. Now, I mean, it did not happen then. I don't know if Ambedkar had lived longer than 1956. Like, I don't know if it might have happened. But the fact is that Anand Teltumde, who was married into the Ambedkar family, ended up in jail almost due to the similar provision. Now, having said that, when the drafting committee changes Article 21 from due process of law, which was there as approved by the Constituent Assembly in its earlier avatar, it actually replaces due process law with procedure established by law. A number of members, K.T. Shah, H.V. Kamath, they actually raise cudgels against it. And H.V. Kamath actually then says, finally, when this is voted upon, after a lot of playing around, when this is finally voted upon, H.V. Kamath says, God save this democracy. And it was incidentally, with this, as well as Article 359 coming into the Constitution, Kamath makes this remark that now that you have approved this, God save this democracy, but it was probably a little providential that Kamath himself was a détenu during the emergency and also a victim of, let's say, the habeas corpus decision. I mean, Ravi Nair actually beautifully recounts as to in an article that was published in one of the anniversaries of the emergency. Ravi Nair, I think it was in Supreme Court Observer. Yeah, Ravi Nair wonderfully recalls as to how Kamath actually explains this. So in some sense, this what we can call the foundational compromise, that this is going to happen, was pointed out very specifically by members inside the Constituent Assembly. But I, for one, would not even buy this argument that it was a product of the times. I mean, it was necessary at that time. This is what Justice Fazil Ali actually says in his winding but he says this may be done by the makers of the Constitution, given the times in which that they made. But then a day should come, he hopes for a day to come, kind of a thing. No, I don't think the Constitution makers ought to have compromised on some of the fundamentals for which they stood. Now, for instance, preventive detention was a clause that that took shape, let's say, the Rowlatt Act. And this is exactly what a number of members in the Constituent Assembly pointed out. So in a sense, it was, I would actually say that there is a beautiful passage from I think Terry Eagleton. Yeah, Terry Eagleton, when he says there is a lot of romantic aspect about poetry, whereas prose actually loses all that romance. And he says there is a certain romanticism when you are into the struggle. And this was true about, those who actually went into the freedom struggle. They participated. There was a romanticism about what freedom is to them. But when it came to prose, or rather sort of, becoming the state themselves, I think, they lost a lot of that ideals. And this compromise that they made, because so many other things that came into the Constitution, that the fault lines were revealed. For instance, the idea of social justice, it was easy. Sort of,
I think there's an issue. Yeah.
Internet snag, yeah.
He has mentioned at the beginning that his internet.
Yeah, he mentioned. Let's wait for him to join again.
Yeah. People are dropping out. You always stay. See,
Hello?
Yeah.
Yeah. Am I audible now?
Yes, sir.
Okay. So, from here, I would actually sort of, like to take on to the concern that, Dr. Venkatesan was expressing about what is the rule of the law. And, I discussed it in the book about, one of the wonderful texts by A.V. Dicey on what is the rule of the law, where he establishes that necessary ingredients of this, or a constitutional scheme, as we would say, would be a legislature that is independent, to which there is an executive that is accountable, and the most important thing being a fearless judiciary. And I think the earliest of the instances when this whole thing of putting down a fearless judiciary happened was in the 1970s, when first, just because they talked about a basic structure doctrine that Indira Gandhi was not pleased with, 3 judges were superseded. And subsequently, thanks to the habeas corpus dissent that Justice Khanna came with, Khanna himself was superseded. But then, like, I mean, the nation still continued, the rest of it, like, there was a constitutional morality, which is again something that Dr. Ambedkar raises in the assembly. I mean, as many as sort of, I mean, 150 jurists signed an open letter and published it in a newspaper, the Times of India and the Indian Express, saying that, I mean, these two judges, Justice Chandrachud and Bhagwati, should not actually be made Chief Justice, even if it meant, that their seniority is sort of, overlooked, kind of a thing. I mean, there was what we can call democracy also needs what we call a civil society, a vibrant, resistant civil society kind of a thing, which I don't see today. Like, I think, I mean, any kind of an atrocious judgment. I mean, what happened to, let's say, like, there are a handful of judges or lawyers who actually sort of, protest, and even their protest is actually there in, let's say, the social media or in the alternate media. It's never in the mainstream media or the legacy media that we talk about. I mean, nobody hears or nobody came across sort of, what happened to Dushyant Dave for what he said, in a sense. So I think, I mean, the nation or, I mean, a constitutional scheme depends entirely on, a nation that is sort of, vibrant and committed to the idea of democracy. And this perhaps is what I think, is definitely sort of, found missing. And yeah, I mean, I'm sure, like, Dr. Venkatesan might also agree with me that, I mean, you can't just blame the constitution or, just the judges alone. The fact is, like, I mean, probably sort of, I mean, the lawyer Niran Day, who appeared for the government in the habeas corpus case, was almost ostracized in the Supreme Court in the Supreme Court. I mean, people would not even sort of, I mean, go to the canteen and sit with him in the same table. And this is something that, just I mean, one of the leading lawyers actually recalled at that point of time. So what we need here is. Pardon?
Niran Day, he was a Solicitor General.
He was a
Solicitor General.
Yeah, he was a Solicitor General, but subsequently,
yeah.
Okay, solicited. Okay, yeah. So I think, I mean, democracy can be preserved, and I think, I mean, what the constitutional scheme that Dicey talks about can be preserved with what we call a society that is also alive to these kind of concerns. And an articulate media and all. Yeah, I think, I mean, there was this whole thing about one nation, one election, and this thing as to whether the Prime Minister should also have a maximum term. I think, these are all questions that have to be raised. And I would say that, like, in even the notorious 42nd Amendment that Indira Gandhi brought about was the culmination of what was called some kind of a public debate. I mean, there were dubious papers that were brought out, one by Antule and all, which I discuss in the book, background to the 42nd Amendment. Likewise, where is that kind of, I mean, I would agree that, like, anybody who talks about it will probably not be provided any space in the legacy media today. But I think, that is where the constitutional scheme seems to have failed. That it has probably sort of, criminalized dissent in a big way. I mean, India in the last decade or even more, and we have witnessed this during the emergency, where dissent is criminalized, and which is where I think the constitutional scheme is threatened. I would still say that, like, it is only threatened. I mean, all hopes are not lost. So I hope, I tried to sort of, address the concerns. And this whole thing of increasing the number of seats in parliament and legislative assemblies to accommodate more number of women who are likely to come with that decision. The same thing was done, let's say, with OBC reservation in higher education institutions. The numbers went up. just in order to ensure that the quote-unquote upper caste meritorious people were not, I mean, their quota of reservation was not reduced further in absolute numbers. So I think this kind of playing around with the law has been happening every time. And how these things will finally sort of pan out in terms of the future of the constitutional scheme is something that I mean honestly, like I hope all of you will agree that this is not something that can be put in a book as much. But it's definitely that, like 75 years, I mean, it was time to take look at a review. And what I have argued in the book is that while social justice has not really completely been sort of shaken, in fact, in the constitutional scheme has allowed for it to sort of not reach the culmination, but at least to start the course of it to start. Economic justice, yes, land reforms is no, I mean, it's got a constitutional protection or a sanction, but it lacks the political will. I mean, it's the political will that actually is lacking. But insofar as political justice is concerned, and I think this is what I've argued, the Constitution actually envisages a fearless judiciary. And we live in times where a judge actually says that, look, I prayed to God before I gave a judgment. So this, and that judge probably was sort of this particular platforms, media platforms, but the legacy media has not really picked it up. It has not really become part of the public discourse in the process, and that is where I think the constitutional scheme faces a bigger threat. So I'm done for the moment.
Thank you, Professor. I have a question for you. So yeah, so the thing is, your book highlights, like I have literally the book, because thank you to Amreen ma'am for this copy. Like if you were here, I would have like got a signed copy from you. So your book highlights the Constitution must be understood not merely as a legal text, right, but as something embedded in a historical and political process. So in that context, how do you see the tension today, like between the constitutional idealism and the realities of political practice?
Okay, I think let me put it this way. I mean, when I started writing the book and when I decided to do the book, and I've said that in my preface also, that this is not going to be something that Granville Austin tried to do in the two books. Austin has done, and he's done justice to what he tried. And this is certainly, it would be too presumptuous on my part to do what the one and only Sirvai could do and has done, the 3 volumes of constitutional history in India, and which he insists on keep on updating. So I'm very clear that I'm not equipped to do that. I don't think I have the ability to do that. So the whole idea here was to sort of look at it as a document that evolves, and how it has evolved in the 75 years. And from what I have argued, it is that there are certain fronts where the evolution has been what I will call on a progressive premise. There are certain aspects that were what I'll call the dark spots at the time of making of the Constitution, which came about. Now, for instance, the amendment to Article 359, that even an emergency under Article 352 is not Article 14, the right to equality or the right to life. I would say that, this by itself was something that the evolution took place thanks to a certain objective reality emerging. or for instance, the Bommai judgment, where they said that, like, I mean, very clearly, like, Ambedkar agrees with an observation made inside the Constituent Assembly. I mean, popularly, everybody attributes it to Ambedkar, but, this was an observation made by another member of the Constituent Assembly. I hope this remains a dead letter word in the Constitution. Ambedkar says, I perhaps agreed with that. I hope. In that sense, this is something that, like, the Supreme Court emerged, but there are also elements, and I would always say, I mean, for instance, habeas corpus. There were High Court judges who actually read it, that, a habeas corpus can hold based on Makhan Singh judgment. Based on a Supreme Court decision in the Makhan Singh case, the High Court very clearly, particularly the the Madhya Pradesh High Court bench, Jabalpur, it very clearly says that, based on Makhan Singh under 481, it can hold. And this is what Khanna elaborates, that you don't need Article 21 for it. It should hold the right to liberty, because right to liberty is also contained in, let's say, Article 19 and so on and so forth. So I think, I mean, it's not that, like, I mean, I also point myself in all kinds of with all his observation about, how the prisoners are taken care in the jails in parental care. What do you call, probably did some kind of a correct his judgments, let's say in Olga Tellis and elsewhere. He sort of, I mean, can be called, like, the man for reasons was Justice Bhagwati. I mean, he was with the establishment in habeas corpus, he was with the establishment in Maneka Gandhi, and he was with the establishment everywhere, kind of a thing. I mean, in fact, even quite recently, there was newspaper articles or some, I think it was in the India Today, as to how actually Bhagwati, after everything, in the 1990s, said that, like, I went wrong with my decision in habeas corpus. So I think, I mean, I think what the book was meant to was try to assess as to what has the Constitution become in its 75 years. And I would end of it say that, like, I mean, it has still sort of, served a limited purpose of ensuring that India did not actually break into the manner in which Winston Churchill and Viscount Simon told the English Parliament on the 6th of December 1946. 3 days before the Constituent Assembly meets for the time, they told the Parliament that this is a bunch of caste Hindus who are going to draft, and, this kind of a constitution and this nation that they're going to build will break down in no time. So in some sense, I would say, like, I mean, that happened, but I would also then institution, but then, like, I mean, it did not, probably because men are wild.
Thank you, Professor. My next question will be to Dr. Venkatesan. Sir, do you think that the judiciary today plays a very transformative role, or has it become more cautious in engaging with the questions of social justice?
It depends on, it's judiciary's attitude differs from case to case.
Yes.
So in some cases, you find that this transformative role has been emphasized by some. Supreme Court as such is a polyvocal court. So you have 34 judges speaking in 34 voices. So that as scholars, we tend to, infer certain commonality, some differences among the benches, some nuances. But ultimately, it is a polyvocal court, which we have to consider as whenever we discuss issues concerning the Supreme Court. So that is why you have dissenting judgments. That is why you have sometimes judges speaking in different voices. You have Justice Buyan, who has been publicly voicing his concerns about some of the recent judgments. And you have Justice Nagaratna again expressing dissent in public. So these things you never came across earlier. So, so there are nuances, there are dissents across the board, okay, which is a healthy phenomenon as far as Supreme Court is concerned. So because these things are coming into the public, right? So whether it is a transformative role or judiciary which is for status quo, I mean, it's very difficult to say overall. It depends. It depends on what, who is the judge, right, and who is the litigant, and what is the issue.
Thank you so much, sir. My last question will be to Dr. Singh. How do we reconcile constitutional guarantees of equality with the persistence of caste-based inequalities in everyday life? So, over to you, sir.
A tough question to answer. I'll just pick from what Professor Anand sort of spoke.
Yeah.
I think larger onus should not be only on the constitution, but rather, let me pick up a very specific example. What Professor Anand has also said, that if you look at the SC/ST Atrocity Act and what recently UGC has come with guidelines, and even earlier before, the kind of response that you have seen, I mean, forget about the legacy media, but what we can see visibly on social media is very wild, very casteist response, something which we had seen in 1990s also, which we call as the anti-caste reservation protest. So where it becomes significant is where judiciary sort of rehashes this very upper caste discourse about reservation, since you very specifically asked a question on caste and how constitution can sort of answer these questions and create a path of social justice. I think that's where it becomes very important when judiciary keep on rehashing this very upper caste discourse. Something, if you read, let's say 1990 Indra Sani judgment, then Ashoka Thakur, and then the question of EWS or reservation for economic weaker section is yet to be settled, or even in fact several cases that are going on whether reservation should go beyond 50% or 60%. In all these cases, every now and then you would see that judiciary invokes certain very specific discourse: secularism, merit, and efficiency. If you look from 1950, these discourse have remained there. So in public and political discourse, even though reservation has become much more acceptable, but the upper caste argument, which are very anti-reservation argument, keep coming back, and judiciary also becomes a one kind of space when judiciary not denies reservation, but sort of critique certain aspect of reservation by invoking that it is sort of goes against the secularism, merit, and efficiency. So I think it's sort of part of a larger problem where we allow anti-reservation sentiments to persist, and then it percolate in judiciary also. So it's both ways. Yeah. Thank you.
Thank you, sir. I would like to open the floor for question from the audience.
Arman, I have a question, but before that, in case somebody wants to ask the attendees, let's say. I don't think so. Okay. So I have a question for you, Professor Anand. And of course, we've seen that how constitution is shaped by negotiations between state institutions, between political movements. We've discussed, I think so Manvinder gave a very insightful argument of contrapuntal reading of the interpretation of the constitution and the concept of dissent, which has come in the conversation today. I want to basically look at meaning making and lived realities, lived experiences. Specifically, I want to know that can a constitution have a shared meaning across a nation? in the sense, or does its meaning fracture across regions? But I'm talking in the context of Kashmir. Basically, I want to understand what meaning does Constitution have for the people of Kashmir, specifically after the abrogation, and does it function more as a lived guarantee of rights or just an abstract instrument of state power? How would we see that? What meaning does it hold for them? Or does it, or is it the same for everyone?
Okay, let me put it this way. I mean, any constitutional scheme, in a sense, as much as it is a constitutional scheme, as much as it is, let's say, the antithesis of monarchy, is also something that actually sort of, is something that it very clearly recognizes a state as in sort of, the executive, the police, and so on and so forth, and whatever it is. I mean, it is centered around the existence of a state. In other words, that it actually sort of, rests upon the state. And in fact, this is something that, I've dealt with in the book as well, that the language in which, let's say, the fundamental rights, particularly the right to freedom, is couched, and also the right to equality is couched. It actually sort of, and I would say that, those who actually drafted it and, who played a role right from the Fundamental Rights Subcommittee, had probably sort of, learned the experience from the Weimar Constitution, which the world actually comes to sort of, express in the Universal Declaration of Human Rights. And the whole framework is that it actually concedes, and, it actually starts from a presumption that violation of rights of the citizen, of the individual, as is not necessarily from another citizen or other citizens. That the state can be the biggest kind of a violator of human rights, and which is the experience that was learned from, let's say, the Weimar Constitution, the way Hitler could actually sort of, do it. So, having said that far, it recognizes the state, and what probably sort of, again, sort of, and this is again something that, was talked about inside the Constituent Assembly. And the whole history of, this reasonable restrictions coming into Article 19. While Article 19 lists, 19.181 lists all the right to freedom, 19.2, 3, 4, 5, and 6 actually sort of, very clearly list out what are the reasonable restrictions. It's a very interesting kind of a trajectory that we notice. The reasonable restrictions were talked about in the earliest of the draft inside the Fundamental Rights Subcommittee, where Munshi played a very major role in drafting the whole scheme. Subsequently, when it comes to the advisory committee, that is where Patel plays the lead role, Sardar Patel, finally, when he introduces what came from the Fundamental Rights Subcommittee into the Constituent Assembly, this is before the drafting committee and all is brought into place. In the second session of the Constituent Assembly, Patel introduces Article 19. It was not 19, it was 12 at that point of time, without any of these reasonable restrictions. In fact, the Fundamental Rights Subcommittee wanted reasonable restrictions. And quite interestingly, in several drafts, that is, sedition was also a reasonable restriction, until Munshi points out in the Constituent Assembly that no, this is a law that put Tilak and Gandhi in jail, and we cannot have this as a restriction. It should get out of the statute books. It should get out of the statute books. It still remains. Now, I think this reasonable restrictions again came in, and then it was brought in again. Once again, the Stormy Petrels inside, those who actually stood for civil liberties all their lives, they actually stand up and say, like Katie Shah actually says, that with all these reasonable restrictions, You are denying what you have said in Article 19.1 with 19.2, 3, 4, 5, and 6. That right to freedom should be unlimited. And then there is this argument that, like, look, like, we cannot have this. And initially, like, there was a consensus that, like, yeah, obscenity. And there's this very, what I will call a very disputable or, obnoxious kind of a word, morality, public morality. And even there, I would say that, like, I think, the Delhi High Court in the Nas Foundation judgment showed a lot of spine actually to discuss this whole concept, to decriminalize 377 of the penal code. So I would say that, like, it is. I mean, let me borrow it from Dr. Venkatesan about what he wrote elsewhere, that it's a constitution still in negotiation. I mean, am I right, Venkat?
You're muted, Dr. Venkatesan.
I couldn't hear what you said because of some audio problem.
You called it that, like, the book says that the constitution is still in negotiation.
Yeah.
So I would still say that, like, there have been all these things, but, the possibilities have been unraveled. And I think the Delhi High Court judgment, not only what you call in the Nas Foundation, but, the Delhi High Court actually stopped the eviction of slum dwellers on either side of the railway track, resorting to Olga Tellis. But where I would actually sort of, argue is Olga Tellis was one stage ahead in terms of, defining the right to life. But what went wrong is it should have taken the next logical course would have been in situ rehabilitation, not rehabilitation elsewhere. Because if right to life is inclusive of the right to livelihood, people who live in the slums should have the right to, continue with their livelihood from where they are. I mean, they cannot. I mean, in Chennai, in fact, I remember having also argued a case where, the slum dwellers residing, let's say, in Malapur, were moved to a place called Semanjeri, which is about 42 kilometers away. But all that the Madras High Court was willing to do then is that, order the government to provide free buses to them from where they are in Semanjeri to come and carry out. This is where I think, the progress that was achieved in Olga Tellis, the direction was sort of, reversed once again. Except for, let's say, Justice Muralidhar's judgment in the, in a case involving slum dwellers on the railway track. Or for that matter, I think, the wonderful dubious compromise that was achieved with regard to the Bhopal gas victims in terms of their compensation. I think Justice Ahmadi, for all the wonderful things that he said in Bombay, including that secularism is a basic feature of the basic structure. Ahmadi cannot be forgotten for what he did in terms of, the sellout that he brokered for the Bhopal gas victims. So in a sense, like, the whole problem is, like, it's possible to sort of, discuss each of the judges and their character, which again I've tried to do in the conclusion, where I've said that, like, there were great judges, and, one of those evidences of that greatness is that there is only one particular judge whose portrait still, it remains there in court number 2 at the Supreme Court, and that is Khanna, because he stood for the rights of the people. I think, there are several factors. So the Constitution, as the principle, I would say, was an injunction. The fundamental rights were drafted in such a manner that these were injunctions against the state. Apart from putting the state with the responsibility to ensure the rights as guaranteed, it was also an injunction against the state. So I think, in that sense, like, it was wonderfully crafted. But what it becomes, let us say, I think, the way the courts have actually dealt with Adivasi rights and their rehabilitation, displacement, and so on and so forth. And, there is this dubious category that the higher judiciary always comes to employ, that this is a government policy and we don't want to interfere. Damn it, I think, land reforms was also a government policy, and the court interfered into it and, said that, there cannot be stumbling block to land reforms. So I think, when this kind of a government policy, policy decisions will not be interfered with, is again some kind of a doctrine that came particularly after the 1980s, I would say, and more importantly into the 1990s. When, I would want to sort of, I'd probably be reminded of, one of A.K. Gopalan's speeches in 1951, in 1952, particularly after the first budget, that the government of India has launched a war against the people of India. This is how he started his speech. So I would say that July 1991 was a watershed where actually this whole business of policy, as designed and defined and wonderfully crafted by a bunch of wise men, should not be questioned. This is where I think the judiciary also began to play ball.
Thank you, Professor. Thank you.
Thank you.
I think there are no questions. Yeah. So in the interest of time, we will move forward towards concluding the session. As we conclude with today's discussion and Professor Anand's work in particular invites us to reflect upon is that the Constitution of India cannot be reduced to a mere legal document. It is in a much deeper sense a historical and moral project shaped by the struggles, aspirations, and contradictions of its time. One of the most compelling ideas that emerge in the distinction between niti and nyaya. While niti refers to the procedural correctness and institutional functioning, nyaya points out towards substantive justice. As in many ways, the enduring question before Indian democracy is whether we have remained confined to niti or whether we have meaningfully moved towards nyaya. At the same time, the constitution was born in conditions that were far from ideal, marked by partition, limited representation, and deep social divisions. Yet the Constituent Assembly functioned as a space of intense deliberation and ethical engagement. This reminds us that the Constitution is not a finished achievement, but an ongoing project. Its promises of justice, of equality, dignity depend on how institutions function, how power is exercised, and how society engages with these ideas. Perhaps the real question then, it is not whether the Constitution has succeeded or not, but whether we as a society has lived up to the transformative vision as it's set for us. So on behalf of Ideas and OP Jindal Global University, I extend my sincere thanks to Professor Anand, Dr. Venkateshan, and Dr. Manvendra Singh for their valuable insights, and to all of you for being a wonderful audience. Thank you so much.
Thank you.
Thank you.
And I must thank all of you for providing this platform. It was
Our
a great
pleasure.
experience.
Thank you,
a
sir.
great experience. And Arman, I'll come to Sonipat and sign, okay?
Yeah, sure. I will be waiting. You are always welcome, sir.
Yeah.
Thank you.
Thank you very much.
Bye-bye.
Bye.
Bye.